Hello everyone, welcome to this video. I'm Marina. Today, I'm going to talk about whether an employee can claim compensation under the Employees Compensation Ordinance if he or she contracts coronavirus. Okay, let's get started. We will cover 4 items today. First, I will give you a brief introduction of the current legislation for employees' compensation, including the occupational disease and accident. Secondly, I would like to share with you my research result, including the meaning of an accident, whether a disease can amount to an accident, as well as the element of causation. Thirdly, I will talk about the requirement of arising in the course of and out of employment, and I will make reference to some Hong Kong cases to help our better understanding of the judicial approach. Lastly, we'll do some case studies based on hypothetical scenarios in a certain trades or industries. According to the definition given by the World Health Organization, WHO, COVID-19 is an infectious disease caused by a newly discovered coronavirus. Under the ECO, a compensable occupational disease is a disease that arises due to the nature of any occupation in which an employee was employed at any time within the prescribed period. Currently, 48 occupational diseases are covered by the ECO. An employee who suffers incapacity arising from a specified occupational disease is entitled to receive the same compensation in the same way as an employee who is injured in an occupational accident. If you may recall, SARS was added as an occupational disease under the Employees Compensation Ordinance, the ECO under an amendment of the ECO with effect on the 8th of February 2005, nearly 2 years after the outbreak of SARS in 2003. As you can see from the screen, Schedule 2 of the ordinance sets out certain specified risk groups, such as medical staff, those responsible for tracing and isolating persons suffering from SARS, research workers, laboratory workers, pathologists, postmortem worker, or funeral services workers. Different from SARS, which is recognized as an occupational disease under the second schedule of ECO, COVID-19 is not currently an occupational disease prescribed under the ECO. Many trade unions in Hong Kong said workers in various sectors are at high risk and can only be protected if COVID-19 is listed as an occupational disease. The Labour Department said that the outbreak situation is still developing, and the amendment can only be made when definite medical and epidemiological information is available. It is also necessary to specify in the legislation what industries have definite risks posed by this disease. As the law now stands, Section 36 of the ECO gives employees the right to recover compensation under the ECO in respect of a disease which is not prescribed as an occupational disease. If the disease is a personal injury by accident arising out of and in the course of employment within the meaning of Section 5 of the ECO. Likewise, the Labour Department has on the 10th of February 2020 and 29th of April 2020 issued a press release stating that although COVID-19 is not a prescribed occupational disease under the second schedule of the ECO, reference was made to the possibility of using Section 36 of the ECO to prove that there was a personal injury by accident arising out of and in the course of employment. They also said that if an employee contracts or suspects to have contracted COVID-19 by accident arising out of and in the course of employment, the employee should inform the employer as soon as possible so that the employer can report the injury to the Labour Department. As at April 17, 2020, The Labour Department has received a total of 21 cases with employees suspected to have contracted COVID-19 as reported by the employers under the ECO. In Hong Kong, there are some trades or industries which are perceived as high-risk groups. Let's have a look at this video before we move on. I'm sorry that the video is only in Cantonese and it's a bit long, so I'll try to skip some content as it plays.
新冠肺炎第三波無聲殺到，連日嚟每日嘅確診個案係過百宗㗎。政府就呼籲市民減少社交活動，鼓勵僱主就俾員工在家工作，但唔少打工仔每日仍然都喺危機之中掙扎求存㗎。
而以下呢幾個工種更加係危中之危添啊！
佢戴住口罩、手套，着住反光衣，一邊推住車仔，一邊喺街頭掃垃圾。佢就戴住面罩，着晒圍裙，再加對水鞋，全副武裝，拎住水槍洗太平地，坑渠要噴，欄杆又要噴，污水濺到一身都係。疫情之下，一班清潔工人每日都要冒住感染病毒嘅風險，處理街上林林總總嘅垃圾，最怕嘅梗係用完嘅口罩啦。
街咧會唔會即係有冇人就咁抌咗啲口罩喺地下？
有啊，有多啊。咁見下我個慢慢執個大手套。口罩嗰啲咩都有人説，我哋咁樣洗到地又抌落嚟，唔知邊個抌啊，我都睇唔到嘅。你驚嗰啲有菌咯？驚啊！你驚唔驚啊？
話咁快又見到一個喺地下，喂，明明隔離就係垃圾桶喎，點解都要周圍掉散播病毒嘅咧？除咗同病毒院舍、食肆、物業管理員同埋的士司機先至有份，哇！咁佢哋嘅情況又係點呢？食肆被認為係較高危嘅地點之一啊！政府一度全日禁止堂食，禁令生效嘅前一日，我哋就去到呢間酒樓睇過。只見到呢位樓面姐姐望住招呼兩位客人，但點知隔離失驚無神彈出咗個阿叔，喂，唔好理咁多啦，開茶先啊！但鏡頭一轉，即刻又有另一位茶客要忙住招呼佢。短分幾鐘，佢已經接觸咗4-5個街外人啦。另一位嘅樓面同事又點呢？見佢係咁出咁轉啦，不停收拾啲碗碟同埋點心籠。佢一邊執客人就一邊講一邊食，真係口水花四濺啊！
都驚㗎，所以第一時間我哋都要戴好口罩啦，做好安全措施先啦。出入你盡量多洗手啊！
有見你戴埋手套添喎，已經
都要洗。
全日禁止堂食生效咗2大日咧，就已經取消啦。樓面員工繼續面對風險，咁廚房員工更加係不能鬆懈啦。
每日都會戴口罩啊，同埋戴帽啊，同埋勤洗手咯。盡量啲嘢又唔好攤太耐咁咯，因為生意比較靜咗，擺得耐咧啲嘢會變。
個口罩會唔會想除咧？
唔會啊，打咗回就都唔會除啊。
至於早前政府宣布為飲食業界提供嘅深喉測試，
喺星期五，
行業就梗係物業管理從業員啦，每日都要同出同入嘅人接觸，真係一路做一路驚啊！
要翻緊而家到自己多人出入。
有喺單棟式住宅做嘢嘅保安員就話：佢哋已經算係比較安全㗎啦。
即係我哋呢啲係私人大廈咧就少啲，除咗即係啲人嚟探人之外，或者裝修嘅之外咧，一般都係住入式嘅。如果做商業大廈嗰啲咧就麻煩啲啦。
但係如果啲三個人入嚟又要幫佢哋登記啊？
呢啲一定要㗎啦，因為而家呢個疫情況你唔登記咧，有啲乜嘢走入嚟仲麻煩。
同人登記、接觸證件都有風險。佢哋仲要每晚巡樓，喺後樓梯逐層行落去，經過每層嘅垃圾桶，佢哋都要小心啲啊！喺疫情期間，佢哋仲多咗樣經常要做嘅工作，就係一個字抹。
係成日都要抹嘅，因為疫情嘅關係。
疫情嘅關係啦，
爆發甚至有院友死亡嘅個案，但係院友個年長，難以要佢哋長期佩戴口罩，加上佢哋可能不時要出入醫院，存在感染風險。職員方面，一般嘅院舍長期都係人手不足，要靠共用兼職散工支撐住。呢啲散工咧，今日做呢間，聽日做嗰間，大大增加咗交叉感染嘅風險啊！咁嘅情況之下，職員同埋院友都可能會中招，所以一方面要停止用兼職，另一方面就算冇請兼職都要加強員工嘅防疫措施。
平時我哋同事翻嚟咧，
我哋為免佢將外邊嗰啲病菌帶入嚟，咁洗完手之後咧，就即刻將舊嘅口罩要換咗，跟住咧就要做個動作咧，就要再噴呢個消毒液啦。咁你要全身都要噴一噴嘅。咁尤其是咧褲腳同埋鞋底。
鞋底。
係啦 ，OK。咁叫佢做完一個基本嘅消毒啦。
量埋體溫，換埋消毒好嘅制服先至可以上樓。咁當然啦，口罩係重要嘅一環。
每位同事每日咧，我都派4個口罩俾佢哋。咁佢翻工翻嚟嘅時候戴第一個啦，翻到嚟都似正話咁樣啦。佢做完呢一個嘅清潔之後咧，就要戴新嘅一個口罩上樓梯做嘢啦。你做嘢做咗一段時間，食完飯之後咧，就換另外一個。咁到放工嗰時就戴另外一個。
為咗控制風險，有院舍嘅員工仲分咗 A、B 兩組，又利用視像嘅設備輔助員工交更，減少員工之間不必要嘅接觸。至於政府免費為業界提供嘅
Okay, let's stop here. This video tells us that there are 4 high-risk groups. They are the cleaning workers, restaurant workers, security guards, and care home workers. In fact, I think the high-risk groups are more than these 4 groups. They also include wet market workers, public light bus taxi driver, hotel staff, supermarket chain worker, container terminal or construction site workers, and also sailors. We also see clusters of infection in other groups not on this list, such as butchers, celebrity, sales, and MTR staff. In order to bring a claim for employees' compensation in respect of COVID-19, the employee has to prove 3 key elements. That is, there is a personal injury by accident, and secondly, that the accident has arisen in the course of his employment, and thirdly, the accident has arisen out of his employment. Okay, now let's look at the meaning of accident. When the word accident is not defined in the ECO, while the word accident is not defined in the ECO, both the UK and Hong Kong courts have adopted the popular and ordinary meaning of the word and interpreted the meaning of accident as referring to an untoward and unexpected event. For example, it was explained by the court in the UK case Fenton against J. Thorley and Company Limited. It is a case where a workman broke the wall of his abdomen by an act of overexertion when trying to turn a wheel. The court held that there was an accident. The court explained that the word accident is not a technical legal term with a clearly defined meaning. Speaking generally, but with reference to legal liabilities, an accident means any unintended and unexpected occurrence which produces hurt or loss. Fenton was followed by Clover, Clayton and Company Limited against Hughes, where the court said, "What, then, is an accident? It has been defined in this House as an unlooked-for mishap or an untoward event, which is not expected or designed." The above cases were adopted and followed in the Hong Kong Court of Appeal case Sit Wing Yi Sibley against Burton Industrial Limited. So now we understand that the word accident simply means an untoward and unexpected event. The next question is, can a disease amount to an accident? As we all know, there is a difference between an external accident and an internal accident. An example of an external accident is someone has been hit by a car and suffered leg abrasion injuries. The event is easily identifiable and the external injuries are visible. On the contrary, an internal accident is something that happens inside our bodies, sometimes without us even knowing, and it could result in injuries invisible from outside the body. An example of this is a rupture of aneurysm. Contraction of a disease like COVID-19 can constitute an accident within the meaning of the ECO. As illustrated in the case authorities below, it is well-established law that an internal accident, that is, a physiological change or accidental infection invisible from outside the body, is capable of being an untoward and unexpected event, and hence falling within the meaning of the term accident in Section 5 of ECO. First, I make reference to the learned author Richard Levis' observation in his book called Compensation for Industrial Injury. He said that although an accident in popular imagination may conjure up some dramatic event causing the emergency services to turn out in an atmosphere of crisis or even disaster, it is apparent that under the industrial scheme, many other types of incident not normally thought of as accidents are included within the term. These may be of the most trivial or unsensational nature and cause injury only in a stealthy manner. Thus, as discussed below, even the slow onset of disease in certain circumstances can be classified as an accident. Because a particular event is required, it does not mean that an accident must be confined to external incidents like mishaps with machinery. It can include an internal physiological change for the worse, as long as it amounts to a personal injury as defined below. All that is required is that such a change was contributed to in a material degree by the claimant's work. Now, let's look at some case authorities. In the landmark UK case, Fife Coal Company Limited against William Young, the court stated that, apart from external accident, there may be what no doubt others as well as myself have called internal accidents, and that a physiological change brought about by an undecided, untoward event happening in the employment might suffice. This principle was adopted in the Hong Kong Court of Appeal case Sid Wing Yi Sibley against Burton Industrial Limited and many other Hong Kong cases as well. Insofar as disease caused by infection is concerned, in the UK House of Lords case Brinton's Limited against Turfy, a workman had been employed sorting wool and he became infected in his eye by an anthrax bacillus and died. The issue was whether there had been an injury by accident within the meaning of the Section 1 of Workmen's Compensation Act. The employer's argument was that the workman had suffered from disease, not injury, and that disease was not an accident. The House of Lords held that there had been both an accident and an injury. It was the accidental entry of the bacillus into the eye which was regarded as the accident, i.e. the accidental infection, and the disease was the injury, i.e. the effect of infection. The court said, the accidental character of the injury is not, I think, removed or displaced by the fact that, like many other accidental injuries, it set up a well-known disease, which was immediately the cause of death. I find as a fact that the anthrax, which was the immediate cause of death, was caused by the accidental alighting of a bacillus from the infected wool on the part of the deceased person, which afforded a harbor in which it could multiply and grow and so cause a malignant disease and consequent death. I can see no distinction in principle between the accidental entry of a spark from an anvil, or the accidental squirting of scalding water, or some poisonous liquid into the eye. The only difference is that, in those cases, the foreign substance would be so large as to be visible. In the case, the foreign substance is microscopic. In another case concerning respiratory infection, Pyrod against Doncaster Corporation, a nurse on duty in a tuberculosis isolation hospital, after contacting with several cases of acute tuberculosis, she herself contracted the disease and claimed workmen's compensation for injury by accident. The majority of the Court of Appeal held that the nurse infection with tuberculosis was an injury by accident. And every time the nurse inhaled a tuberculosis germ, an accident occurred. And that although the exact dates on which these accidents could not be fixed, yet it was plain that all these accidents took place in the course of her employment, and that the infection was due to one or more of them. The nurse succeeded in her claim for employees' compensation. The court commented that, I'll just read from the words in blue. Many diseases cannot in their nature be due to accident, but some may be. These include the diseases produced or precipitated by trauma, that is, injury or shock, by exposure or exertion, by infection or contagion, or by contact with or invasion by foreign elements. If one of these diseases is due to an accident or series of accidents, it may form the subject of compensation under the Workmen's Compensation Acts. Applying this test, if a disease can be attributed to one external factor only, whether that factor be trauma, exposure, exertion, or infection, or such like, then it is undoubtedly due to an accident, even though the precise occasion on which it occurred cannot be ascertained. Accordingly, it can be safely concluded that, even though COVID-19 is a disease which is invisible from outside the body, it does not prevent an employee from proving that an accident has occurred and from claiming compensation under the ECO. Next, we will talk about the element of causation. In determining whether there was an injury by accident within the meaning of Section 5 of ECO, the burden of proving injury or death by which such untoward and unexpected event is on the employee. It must be proved by the employee on a balance of probabilities, that is more than 50% chance that there was a distinct event, that is the accident, which produced the injury. In the context of COVID-19, it would not be a light burden on the employee because it is often difficult or impossible to know the precise source, when or where one contracted the virus. Hence, it is believed that evidence from experts in the field of infectious disease, as well as the surveillance data or epidemiological investigation data from the Center for Health Protection will be required in determining this issue. For example, the expert may give evidence on the probable mode of contracting the virus, the estimated period during which the virus was contracted, and the incubation period, that is the time between exposure to the virus and symptom onset, etc. I believe there are some relevant factors which may impact upon a judge's mind when determining the issue of causation in addition to expert evidence and other scientific evidence. These factors are not exhaustive, but I think they will tip the balance when the court decides whether the contracting of the COVID-19 was caused or contributed by his employment. The first column shows factors which may tip the balance in favor of the employee, such as if the employee is in a higher risk role, such as front-facing role with lots of contact with different people, or jobs which require the employee to remain in a confined space where it is easy to come into contact with the droplets from sneezing or coughing of an infected individual. For example, a doctor in a hospital, front desk staff in a hotel, restaurant worker, cashier in a supermarket, and bus driver, etc. Also, if there is the presence of a cluster of COVID-19 infection in the workplace, and the employee had come into close contact with confirmed cases within the cluster. Also, if employees share facilities in close quarters, such as crammed quarters for rest breaks, toilet showers, This will be a factor which will tip the balance in favor of the employee. In addition, where employer does not have an infectious disease preparedness and response plan, or where the employer does not implement any sufficient infection prevention measures. The second column shows those factors which may tip the balance in favor of the employer. They include when the employee is in a lower risk role, such as office manager who usually stays in his own room during working hours. The absence of a cluster of COVID-19 infection in the workplace, or where there is limited sharing of activities, or where the employer has engineering control in place, such as increasing ventilation rates in the work environment, installing high-efficiency air filters, installing physical barriers such as clear plastic sneeze guards. Also, where the employer has an infectious disease preparedness and response plan, including providing a face mask and asking the employees to wear them, the need for social distancing, staggered work shifts, and other exposure-reducing measures. Lastly, where the employer implemented sufficient infection prevention measures, such as promoting frequent and thorough hand washing, providing workers, customers, and worksite visitors with a place to wash their hands, providing alcohol-based hand rubs, encourage employees to stay home if they are sick, encourage respiratory etiquette, including covering coughs and sneezes. And pausing here, I just want to highlight that, as mentioned by Cott in numerous cases, weighing different factors does not mean that it is a mechanical exercise of running through items on a checklist to see whether they are present in or absent from a given situation. The object of the exercise is to paint a picture from the accumulation of detail. The overall effect can only be appreciated by standing back from the detailed picture which has been painted, by viewing it from a distance. It is a matter of evaluation of the overall effect of the detail, which is not necessarily the same as the sum total of the individual details. Not all details are of equal weight or importance in any given situation. Also, the details may also vary in importance from one situation to another. So we have finished part 2, and now we'll move on to part 3. Apart from proving that the disease was an injury by accident, an employee needs to prove that the accident occurred in the course of and arise out of his employment. The phrase "in the course of employment" means in the course of work which the employee is employed to do and what is incidental to it. This is confirmed in the Hong Kong Court of Appeal case Chen Xiu-mei against Li Xiu-wo and another. The phrase "arising out of employment" points to the origin or cause of the accident which we have covered earlier. As mentioned, the employee bears the burden of proving that it is more likely than not that the disease was contributed to by his employment. The employment does not have to be the only or main cause of the disease. It is sufficient that the employment or work is a contributory cause of the disease. In determining whether the employee contracted COVID-19 in the course of his employment, we need to know what the employee was doing at the material time. For example, having meal together or taking naps at the resting place provided by the employer would be some of the relevant scenarios, as these activities carry a higher risk of infection, as shown by the recent confirmed cases in Hong Kong. In this regard, the UK courts acknowledge that the taking of a meal may not create an interruption in the course of one's employment, save and except in special circumstances where the employee is away from work for his own pleasure. In other words, an employee having lunch or rest breaks at workplace may still be in the course of employment. In the case of Armstrong, Whitworth and Company against Redford, a worker crossed the street to another part of the employer's premises in order to go to a staff canteen during the dinner hour. After finishing her dinner, the worker was hurrying down a flight of stone stairs leading from the canteen into the street in order to return to her work, when she slipped and broke her ankle. The House of Lords held that the accident occurred in the course of and out of her employment. The court's reasoning was as follows. The court says that the meaning of the words in the course of employment means in the course of work which the workman is employed to do and what is incidental to it. I think that a midday meal may be incidental to an employment, such as that of the respondent, which commenced at 6 in the morning, and that the taking of such meal did not, as a matter of law in itself, and apart from special circumstances, create an interruption in the course of her employment. There are no special circumstances in the present case, such as, for instance, arise when an employee is away from his work, not in the course of employment, but for his own pleasure or business. This UK approach was applied by the Hong Kong court in the case of Chen Yao Wei against Chun Ki Seafood Restaurant, where the employee working as a waiter had just finished taking his rest inside the restaurant and was descending a staircase for free meals provided by his employer, when he slipped and fell on an internal staircase. The court held that when the employee stepped onto the staircase, he was doing an act reasonably and naturally incidental to his employment, and therefore the accident occurred in the course of his employment. In this case, the judge took the view that taking a rest at the employer's place during recess or taking meals at the employer's premises may not necessarily amount to an interruption of his course of work. In other words, the employee may still be in the course of his employment. The court in that case considered that, while the employee was free to do other things during the recess time, but it was only natural for him to rest during the recess in order to become refreshed and energetic for the night shift duty. Therefore, his staying in the restaurant during recess was reasonably incidental to his employment. In such way, he could get refreshed and energetic. In a sense, he was equipping himself physically to cope with the night shift work. The court also took into account that the employer had given permission to the employee to stay and rest in the restaurant. Another factor to consider is that the staircase in question was the only access and egress between the ground level where the meal place was and the upper levels where he rested. If the employee had to take the meal, he had to use the stairs to go to the ground level. As to the provision of free meal, the court did not think that the employer was doing this for benevolent reasons. This arrangement was beneficial to the employer as much as to the employee, because the meals energized the employee. This arrangement also avoided the possibility of his coming back late from meal if he had to take the meal elsewhere. So, the provision of meal at the employer's place was of mutual benefit to both the employer and the employee. The court thinks that if the employee did not work for this employer, he would not be provided with such meals. The provision of meals was incidental to the employee's employment. It follows that the going down the stairs after resting during recess in the restaurant to take the meal was also incidental to his employment. Likewise, in the case of Yao Kam Ching and Manfat Company Limited, this is an easy action in 2013. The employer operated a restaurant in Kiu Kiang Street in Sham Shui Po. The premises of the restaurant occupied both sides of the street. The employees had to work on the premises on both sides of the street. As a result, they had to cross the road frequently. On the day of the accident at around 5 p.m., she was taking her meal break and was about to have her free meal with her colleagues in one of the premises. She walked to the other side of the road in order to get some bowls for the meals, and was hit by a taxi when she returned with the bowls. The judge held that the employee was acting in the course of her employment. The employer in that case tried to argue that because the employee were free to meal elsewhere, they were not in the course of employment simply because the employer happened to have offered a free meal, and that they chose to dine at the workplace. The court rejected this argument. The judge held that the phrase "in the course of employment" does not mean only the currency of his work engagement, but it also includes what is incidental to his employment. The court took into account that the employees were given short breaks for the 2 meals which would usually last between 20 to 30 minutes, and so they would dine at the workplace. Accordingly, the court is satisfied that by crossing the road to obtain the bowls for the meal, the employee was engaged in an activity reasonably incidental to her employment. The court even made reference to the meal and lunchtime clause in the EC insurance policy taken out by the employer, although the judge did not expressly state whether this is a relevant consideration. According to this clause, it was agreed that in the event of any employee of the insured staying in the insured's premises, meal and lunchtime being injured or killed shall be deemed to have arisen out of and in the course of the employee's employment. Applying the principles in these cases, the fact that an employee was taking a rest or having a meal at the workplace where he contracted COVID-19 may not prevent him from being regarded as acting in the course of employment. As can be seen from the court's reasoning, it is a question of facts, and the court would adopt a broad approach in weighing all the facts and evidence. Finally, we have come to the last part of this talk. I have prepared some hypothetical scenarios in several sectors or industries, namely the container terminal or construction industry, supermarket chains, and bus companies. First, we will talk about terminal or construction site cases. In scenario A, there was a cluster of COVID-19 infection at the workplace resting room in a container terminal, which is a crammed quarter with a lot of bunk beds and dining tables, and workers shared those facilities and did not wear masks when they were sleeping or eating. The test results of the environmental samples taken from the resting room were positive. A terminal worker who contracted the virus, together with several other terminal workers who also contracted the virus at about the same time and who had used the resting room, has used the resting room on a daily basis. There is no other high-risk factor for this terminal worker. There is no confirmed case in the building where he resides. He wore a face mask when traveling to work and during work, but he took off his mask when sleeping or eating in the resting room, just like other workers in the resting room. In this scenario, subject to expert evidence, I think there is a good chance that the court would take into account the numerous high-risk factors and may draw inference that it is more likely than not that there was an injury by accident, that is, the disease contracted by accidental infection at the resting place, and that the accident may occur in the course of employment because, as the case authority suggests, taking a rest at a resting place provided by his employer in order to recuperate for work purpose would still be regarded as acting in the course of one's employment. Let's look at scenario B. This is a construction site scenario. A general laborer contracted coronavirus and claims EC. There was no cluster of infection at the workplace, but there was a site project manager who is a confirmed case. The site project manager's wife is a nurse, and she contracted the virus earlier on, and the project manager was regarded as a close contact. The project manager worked at the site for a few days before his wife became a confirmed case and he was quarantined. The test results of the environmental samples taken from the workplace show negative. The general laborer working at the same site showed symptoms of coronavirus a few days after the project manager ceased working at the site. The general laborer lived in a building in Shui Chun Old Estate, where there were numerous confirmed cases of coronavirus. He wore a mask during work. He had not seen or spoken with the project manager while he was working at the site. In this scenario, subject to expert evidence, I consider it would be more difficult for the employee to establish the causal link between his contraction of the disease and his employment on a balance of probabilities, because he is also exposed to other high-risk factors, such as numerous confirmed cases in the building where he lives. Okay, we now turn to look at supermarket chain cases. In scenario A cashier lived in Jordan and worked at a supermarket in Tiwanshan. Apart from working as a cashier, she was also required to stack and sort the goods. She wore a face mask during work, but she did not wear a clear plastic face shield. There was no compulsory requirement for customers to wear face masks in the supermarket, nor was there any step to measure the customer's body temperature before entrance. There were 7 confirmed cases who lived in Tiwanshan and had visited the supermarket about a week before this cashier showed symptoms of coronavirus. The test results of the environmental samples taken from the supermarket were positive. In this situation, subject to expert evidence, in the absence of any non-work-related risk factor, I think there is a reasonable chance that the court may take into account the risk factors such as the supermarket being located in a high-risk location, Tiwanshan, and that the supermarket was visited by numerous confirmed cases. And the court may draw inference that the employee had likely contracted the virus by reason of her employment, through possible close contacts with the confirmed cases who visited the supermarket or contaminated surfaces. Let's look at scenario B. A cashier lives in Tiwanshan and worked as a supermarket in Repulse Bay. There was 1 confirmed case who had visited the supermarket a week before this cashier showed symptoms of coronavirus. She wore a mask and clear plastic face shield during work. There was compulsory requirement for customers to wear face masks in the supermarket, and all customers need to have their body temperature measured before entering. There had been regular disinfection of the cashier counter and the store areas twice a day, even before the confirmed case visited the store. The test results of the environmental samples taken from the supermarket show negative. The cashier's husband was a taxi driver and showed symptoms and later confirmed of coronavirus 5 days before the cashier showed symptoms. The cashier's husband was a confirmed case of an infection cluster involving 6 taxi drivers. In this scenario, as the cashier is also exposed to other non-work-related risk factors, namely that she lives in Tiwanshan and her husband is also in a high-risk occupation and being a confirmed case of an infection cluster. Subject to expert evidence, it will be an uphill task for the employee to persuade the court to accept on a balance of probabilities that she contracted the virus through her work at the supermarket. Lastly, we will look at bus company case. A bus driver contracted coronavirus and claimed EC. The bus driver wore a face mask during work. Before his incubation period, the government's compulsory requirement for all public transport passengers to wear masks was not yet in place. Some passengers did not wear masks when traveling on the bus. He recalled a passenger who was standing adjacent to him did not wear a mask, and he coughed a lot during the bus journey, which lasted for around 20 minutes. There was no record that any bus passenger on that day was a confirmed case. In this case, except the fact that the bus driver was in a relatively higher risk occupation, and his allegation that a passenger coughed in his face, there is little evidence upon which the court may make an inference that the coronavirus was contracted through work. So unless there is other more persuasive evidence, we believe the bus driver would have difficulty in proving his EC claim against the bus companies. Further, if the bus driver contracted the virus during a time when the government's compulsory requirement for all public transport passengers to wear a mask was in place, i.e. almost all passengers would be wearing masks during the journey, and if the bus company had given clear guidance to bus drivers that they can refuse a passenger without face mask to board a bus, the chance of the court finding in favor of the employee may even be lower, following the control and reduction of the risk factors. Another interesting question is, if contracting COVID-19 can be an accident within the meaning of ECO, how about common cold? Can an employee claim EC if he alleged that he caught the cold from work or from his colleagues? Both COVID-19 and common cold can be a disease that general public is exposed to, and they have a similar disease presentation. That is, they both cause respiratory disease. Secondly, both are transmitted by contact and droplets. However, there are some important differences. For example, while COVID-19 is caused by a single virus called SARS-CoV-2, common cold isn't caused by a single virus. There are over 200 different viruses that can cause the common cold. So one can get a cold multiple times because there are different viruses. Secondly, while COVID-19 confirmed cases can be traced using surveillance system and contact tracing, which is what our government is doing now, it would be tremendously difficult to trace the source of the common cold, which is caused by different viruses and can come from endless other sources. Therefore, it would be extremely difficult for the cold viruses to be identified as coming from his employment. Accordingly, while contracting a disease is capable of being an accident under ECO, in ordinary circumstances, it will be extremely difficult and almost impossible for an employee suffering from common cold to prove the causation element, i.e. that the source of the common cold originates from his employment, because there are simply too many uncertainties as to the sources from which the employee could have contracted the cold viruses. To sum up, an employee who has contracted the coronavirus may successfully claim against his employer for employees' compensation under the ECO if he can prove that he has contracted the disease by accident arising out of and in the course of employment. While contracting of COVID-19 can fall within the meaning of an accident under ECO, it will certainly be a challenge for the employee to prove that the contracting of the virus was contributed to by his employment. Ultimately, the determination of this issue would be highly fact-sensitive, and it depends on the facts and evidence. It is most likely that evidence from experts in the field of infectious disease will be required if the matter proceeds to litigation. The judge will weigh all relevant circumstances by making an informed and considered appreciation of the whole picture. That being said, we shall keep an eye on any amendment to be made on the ECO to include COVID-19 as prescribed occupational disease under the ECO in the future. So I've come to the end of my presentation. Thank you for watching, and I hope this video is helpful to you. Take care, and I'll see you next time. Bye-bye.